This is a continuation of the legal panel discussions, and we've got the wonderful Rosanna Hoffmann from UNOOSA to lead it, to chair it, and of course we have some fabulous speakers coming up as well. So please, anybody who can hear my voice beyond the curtains, please come into this room. Please come into this room, because we have great minds. And as Jim said to me just now, and Stephen also said to me, we like a little bit of positive debate. Positive debate moves the conversation forward, and that's what's going to happen after the speeches today. Just one more thing to say to you. You can also vote for the posters, your favorite posters. So perhaps in the coffee breaks, definitely not during the sessions. And this evening, tomorrow as well, you can go and vote for your favorite poster. You just have to bring your badge to the reception, which is just at the end of the poster corridor, and then vote for your favorite posters. But I don't want to take up the time, because the time now is going to be most beneficially used by the true experts sitting in front of me, and indeed the wonderful Rosanna. So Rosanna, this is your session.
Lisa, thank you so much for that lovely introduction. And indeed, likewise, for those of you outside of the room, if you can hear my voice, please come join us. We're going to continue our legal and regulatory discussions around space resource activities. And I have to say, I got a bit nervous when I was hearing the panel discussion during our first session. And I thought, wow, are we going to able to, or are we going to top that with the discussions in panel 2? And looking at the different topics that are proposed to be covered, I think we will be able to at least be as good and interesting. So, but this is not about me. I'm just here to moderate. So I'll take a seat right over here. And I'm very, very excited to please welcome our first speaker, who's from the Sorbonne Institute for Legal Research at the Paris Panthéon-Sorbonne, who will set the stage by mapping how the patchwork of national space resource laws creates, and now we have a point for discussion here, conflict of laws, problems for any actual extraction activity. So, Lucillien Denoyelle, if you could please join me up here on stage. Thank you so much.
Thank you. Thank you very much for this presentation, and thank you very much for the opportunity to present at such a wonderful event at the Space Resources Week. Today, I invite you to step away from the traditional debates and maybe a bit saturated debates of public international law regarding space resource extraction and utilization, and instead look a step aside and look at this issue through the prism of private international law and conflict of laws theory. Over the next 12 minutes, and I try to be brief, I will try to demonstrate that we are currently assisting a fragmentation of laws, domestic laws, stressing even more legal uncertainty, which can be resolved by clarifying, firstly, space law ambiguities and using private international law mechanisms. Space resource extraction is no longer a theoretical exercise. It is transitioning from concept to commercial reality and viability, and you are the best example of this statement. However, a commercial maturity accelerates, yes, but we are witnessing legal variance across different jurisdictions. National legal regimes over space resources utilization are in development in numerous states, but they are also diverging a bit. Predictable title and enforceable rights in REM, which means rights over properties and notably ownership, are absolute prerequisites for securing investment. Thus, legal uncertainty may not be the best way to create projects for SRE and may be highly problematic for professional actors and operators. Practically speaking, the divergence results in a legal and commercial uncertainty For example, if a company extracts a resource, but their rights over that resource are not recognized across the jurisdiction, and because these operations are by nature transnational, the economic foundation and the chains of titles would collapse. This brings us to the core paradox of this legal architecture we have nowadays. On the one hand, I will be really brief on that because you know it already, the Article 2 of the Outer Space Treaty and the non-appropriation principle, which prohibits the national appropriation of outer space and celestial bodies by claims of sovereignty, by means of use of occupation, or by any other means. And to put it in a nutshell and in a fancy legal wording, outer space is a res extra commercium. No ownership rights are allowed over outer space and celestial bodies themselves and over their territories. On the other hand, we've got national practice emerging, and key states are unilaterally enacting legislation that grants ownership rights to private operators over extracted space resources. And that's why I'm speaking about space resource extraction and not space resource utilization, because I'm really focusing on the title which are coming from the extraction of resources. And herein lies the paradox. We are seeing the emergence of global gateways, and in a way, we've seen that the United States, the Luxembourg, the United Arab Emirates, and Japanese laws are taking common goal of enabling commercial extraction, and their legislative visions present different regulatory approaches. This variance can be significant, particularly in licensing and authorization procedures. And this is what I call an effectiveness gap, because surely these statutes, they grant domestic certainty, but it does not necessarily guarantee international effectiveness of the titles that are created under those domestic laws. A property right granted by one jurisdiction, for example in the US, may not be recognized and even less enforceable in another jurisdiction, even more so if this jurisdiction has no framework for space resource extraction and utilization. One of the main divergence, but there are all others one, it's the model that is used for creating titles. At first, we've got the US, which has adopted an activity-based model, where rights stems directly from the commencement of the extraction activity. Conversely, we've got Luxembourg, the United Arab Emirates, and Japan in all sorts of ways, but have adopted a common authorization model, conditioning rights on formal governmental approval and ongoing state supervision, and even public scrutiny before the parliament for the Japanese law, for example. This difference creates a legal challenge, and a legal challenge of recognition of rights. A title established under one national law faces a very real risk of non-recognition in another jurisdiction. So to map this, there is, well, a fragmentation horizontally between domestic laws and also vertically between an international layer with another fancy Latin term, the Corpus Juris Specialis, which is mainly the UN space treaties, including the beautiful but unfortunately not very successful Moon Agreement, which are highly relevant today and which was said yesterday is real too, because UN space treaties and the outer space treaties is really not out of date. And it is because we are using it so much that we are now testing its limits. And it is very interesting to see that the outer space treaty from the 1960s, 1967, is just reaching its full potential today, truly an instrument which was ahead of its time. Beneath this international layer, we've got, of course, the national layer that I talked about just before, and soft law guidelines, or I will just not present again all the work of the working group at the Corpus, the Hague International building blocks also, which are very important and very interesting. And for example, something that we can see in both, and which is interesting, and we'll go back a bit later, in Principle 10 of the Corpus draft and in the Hague building blocks, is the creation of a registry, for example, for space resources. But this fragmentation may present significant market problems regarding title and transfer across borders. Again, it is a problem of recognition between different jurisdictions. So, a common adage in insurance is if there is a maybe, it's either a no or it's a pricey yes. And this is exactly what it is for now with the legal uncertainty and what is also applicable to the matter at hand, I think. This is where private international law is decisive, as it is a coordination layer, and it will be the base after clarifying all ambiguities of the Outer Space Treaty and the Corpus Juris Specialis, which will be the case, and which is already a bit the case, and will be a coordination mechanism and very powerful mechanism. Our legal challenge, therefore, is to identify the applicable law for international space resource extraction. I will go really briefly on that, because I just have to say that I'm talking about things and assets. There are different things. Thing is an object where no rights can be attached to, whereas an asset or property is something on which rights can be attached to a legal subject. So when we are talking about extracted resources, space resources, we're talking about assets for these reasons. And this brings us to the void of applicable law, because when dealing with rights in rem, which means ownership on things, on Earth we've got two main principles. We've got the lex rei citae, and we've got the lex loci actus, but they both, the base is the law of the territory where the asset, where the immovable property, or where the action is underdoing, which is not possible in celestial bodies. So we can bring other conflict of law mechanisms. For example, we can take the lex registrationis, which is a link between the state which registers the spacecraft and the spacecraft which is underdoing, the team of the spacecraft which is underdoing the activity. And it's a bit for the same of the law of the flag of the vessel, if you remember the Article 92 of the United Nations Convention of the Law of the Sea. We've got also the lex auctoritatis. In this, we are using the law of the state of continuous supervision. And we can also have lex contractus and the choice of law by the parties. And we can also have, a registry, a credible registry, and use this law of the registry as another lex registrationis for space resources. Finally, in conclusion and key takeaways, very briefly, we are able to move past abstract rhetoric right now. The real challenge for space resource extraction is not anymore the question of ownership, I think, but the practical cross-border recognition of rights. And we must work on private international law solutions and conflict of law mechanisms inside future national space laws, which is missing right now. And I must say that we are really at the brink of legal certainty, and it's really achievable today. By applying rigorous conflict of law methodologies, we can govern extra-atmospheric assets effectively, and using the good choice of law, mitigating systematic risk to preserve legal certainty in the province of all humankind. Thank you very much for your attention.
Lucillien, I have to say, you were on the 10-minute mark, so congratulations on keeping on the time so well, but of course also congratulations on covering such an important topic. I think the issue of fragmentation, it comes up again and again when discussing space resource activities. What we're doing now is a bit different to panel one. I should have mentioned at the beginning, we're going to do one question after each of the presentations, a question from the audience, I hope. If not, I have prepared ones as well. And then together with Antonino, I see you in the back. Yes, hi. We're going to do a community Q&A with all of the panelists, so panel one and panel two. So please, everyone, stay in the room. We're going to really have an active debate, hopefully, around these questions. Okay, but now over to you, and I see Jim, you have a question, please.
Lucillien, lovely presentation. Thank you for such clarity. One question I have, between the extractive function of the US enabling premise and the authorization premise of the remaining three, what would be the bridge to create that common international framing?
Well, thank you very much for this question. It's a divergence, but not really something too complicated to coordinate, to be honest. It's only that the philosophy is different on the creation of the rights, but what the right is created over the extracted space resources. It is granted either in the US space law and also in the UAE, Japan, and Luxembourg space law. The main problem will be with other nations and which do not have legal frameworks. And the possible problem that may happen and may rise is when there is no authorization, but it's a transnational consortium between, for example, US and Luxembourg cooperation, which can be a problem if we have not both of these characteristics of authorization and actively extracting resources.
All right, thank you so much, and please do stay ready for the community Q&A after. Thank you. All right, we're going to continue on with a topic that I think goes somewhat hand in hand. I mean, they all somehow do. We're discussing legal aspects of space resources after all, but we're talking about mission authorization, which was addressed already here, specifically the missing link for space resource operations. So next up is Neha Dagley from Space Market Legal Advisory. Thank you so much.
Good afternoon, everyone. I am Neha Dagley, and today I will be presenting on mission authorization, the missing link in space resource operations. My firm is called Space Market Legal Advisory. I am based in Miami, Florida, and I'm very excited to be here presenting on this particular topic. Novel space activities are driving forward in a new space economy at a pace that legal frameworks are not keeping up with. Industry is ahead of the law, and certainly this does not come as a surprise to anyone in this room. Currently in the US, industry needs at least 4 different licenses from 3 different agencies, not including export control issues. These 3 distinct agencies, FAA for launch, reentry, and payload review, the FCC for spectrum and orbital debris management, OSC and NOAA for remote sensing payloads. This is already a very intricate and comprehensive regulatory framework for existing space activities. But there is currently no dedicated or direct path for licensing and authorization of novel space activities, including in-space manufacturing, orbital computing, lunar surface operations, lunar orbit operations, space resource utilization, RPO, and satellite servicing. Before we talk about what we don't have, though, let's talk about what we do have. Because all of these foundations and frameworks are very much interconnected. In 2015, the CSLCA established that United States citizens and companies have the right to own, possess, sell, use, and transport space resources that they've obtained, with an important qualifier: in accordance with the international obligations of the United States and with applicable law. Now, the CSLCA answered the ownership question quite well from the US front, but not the authorization question. Shortly after the CSLCA, something very telling happened. And as my colleague before me talked about, Luxembourg, Japan, UAE have enacted national legislation covering space resources. Now, in parallel timing, we also have the US-led Artemis Accords, which now has 64 signatories. The Artemis Accords came about in 2020. So when you start looking at the timing of how these things are coming about, there is a very key directional signal here. We have legal architecture and some consensus on critical topics related to space resource issues coming together slowly, but the national regulatory framework as to authorization of novel space activities continues to be rapidly outpaced. And this lack of a clear and direct pathway for the authorization of novel space activities has real consequences. So, it directly impacts how much and how quickly capital can flow into these activities. It impacts insurance frameworks, and it can stall growth due to duplicative and parallel regulatory burdens. Not to mention that there is no clear answer as to how the Article 6 obligation is satisfied regarding novel space activities. Now, likely recognizing some of these consequences comes along Executive Order 14335 last year by the current administration. In part, this order directed the Secretary of Commerce to propose a process for individualized mission authorizations for activities that are covered by Article 6 of the Outer Space Treaty, but not clearly or straightforwardly governed by existing regulatory frameworks, and with the goal of expediting and streamlining authorizations. This is a key part of that executive order. Following this particular order, we have the Office of Space Commerce that released an updated space commerce certification proposal in March of this year. Let's look at the core architecture of this proposal. First, this will be a voluntary process, unified, and activity-based. But participation, it's important to note that participation in this process will not relieve an operator from obtaining existing licensing or authorization requirements. Any US entity can apply. It applies only to novel space activities. There are no fees proposed at this time, and it will be administered by the Secretary of Commerce. Also, there will be a single application instead of 3 or 4 different authorization tracks with different agencies. Simultaneous interagency review and on a single clock, a presumption of approval, and a 180-day hard cap to render a decision of yes, no, or yes with some conditions. According to the Office of Space Commerce, the application was actually designed to be limited, deliberately limited, allowing operators without large compliance teams or budgets to navigate it. Let's take a quick look at what is inside the proposed application. I am running short on time, so you can have a look at the screen here. And what I'd like to point out truly here is you don't see any specifics regarding a specific novel space activity. And that was on purpose. The Office of Space Commerce has specifically said that it would be impractical to articulate rules for each novel activity immediately, recognizing that some activities have never been done before and some are at a very early stage. So they intend to do this through experience and with industry and with collaboration through a voluntary process rather than through abstract discussions. And what does the process look like? So once the applicant submits, the Department of Commerce does its own due diligence and then circulates it for interagency review. And you can see a number of agencies are listed here. Each agency has 30 days to complete its review with a 230-day extension, which brings us to a 180-day hard cap for timing. There is also an ongoing supervision point in the proposal itself. I'd like to point out that there are 4 specific grounds of denial, which means that there cannot be a generalized basis for denying any one of these applications. So it has to be something related to the fact that the applicant cannot comply, Maybe it affects national security interest, international obligations of the United States, or harms foreign relations, or there is some unacceptable danger within that proposed mission. Each one of these is categorized or classified, really, or qualified, that even if some of these are found to be true, they have to make an effort to propose some conditions and allow it where they can. So it's intended to be as least burdensome as possible. So where did this proposal stand now? Well, it's still in the industry comment process, after which there will be an implementation directive. And after that, the OSC will start accepting applications and beginning the review process. There is still a congressional gap here, so until Congress sinks its teeth into this, it's not going to be binding. It will continue to remain voluntary. Let's look at our key takeaways. So this is the first purpose-built authorization in the United States framework. We can see that the architecture of the proposal is structurally sound because it does not try to preemptively regulate every type of novel space activity. It intends to be, again, an iterative process that will hopefully develop norms along with collaboration with industry, workflows, and then at the end, we may have some required procedures. My guess would be at least 10 years down the line. It can have immediate commercial value. For those who are operators in the audience, you would now have something that gives you a yes, right? You can take that yes to your potential stakeholders, your investors, and other folks, where you have something from the Department of Commerce and the Office of Space Commerce authorizing your novel space activity. So there is definitely a gap that's filled there. Voluntary is, of course, the bridge, not the destination, as we've already discussed. And the certification is an opportunity to set a global standard. Thank you for your attention.
Thank you so much, Neha. I have to say this is the most in-depth presentation I've heard on the new proposal. We heard a presentation, Stephen, just 2 weeks ago from Gabe Sweeney. He was at the UN from the Office of Space Commerce presenting exactly the proposal that you did, but you did a fantastic job. Sorry, what? You had to cut it down. You did keep it to 10 minutes, though, so congrats on that. All right, over to the audience. I'm sure you have questions on this. I see a few, please, in the back. Yes.
Simon Drake from the Lunar Resources Registry. Could you define a US entity in terms of how foreign ownership can complicate the process?
Ownership can complicate the process?
So my understanding is a foreign entity can apply for this process, but, sorry, an American entity or an American individual, but can that entity be foreign owned? And would that complicate the process of getting some kind of permission or acknowledgement?
Right, so there is a definition of what is considered a US entity under the federal statutes, and I'd be happy to share that with you after. But it basically says that if a company is at least 51% US owned, which implicates that if it's part foreign owned, it doesn't necessarily present a problem. But I'll put a caveat on that. When all of the different agencies are conducting their individual review, I am certain that they're going to look at where the foreign ownership interest is coming from. And of course, putting aside any ITAR discussion for now, but looking only at the process that I was talking about, they are going to look at that in their review process, and whether or not it presents a problem remains to be seen, since we don't know, how the Office of Space Commerce is going to handle these things. But if you look at the denial grounds, they're pretty broadly phrased.
Thank you.
All right, I see that we have 1 or 2 more questions. I would, however, ask that you keep them for the community Q&A that we're going to do. The whole idea is then really to go back to you with the questions in that community round. So thank you so much for now. Okay, we're now going to continue on with a topic that I believe we already touched upon quite well in panel 1. It's all about the relevance of planetary protection, although I think the focus was a bit more on planetary defense. Now we have planetary protection for lunar exploration and resource utilization, and we have a speaker here from the Technical University of Munich, Philipp Reiss. The floor is yours. Thank you so much.
Thank you for the kind introduction. I hope everybody can hear me all right. So we're switching gears a little bit. I'm going to talk about planetary protection now. And I am actually speaking here on behalf of a larger group. That's the working group that was tasked by the European Space Agency and coordinated by the European Science Foundation. If you want to know more about what the European Science Foundation does, there's a booth outside. So you can ask them what else they're doing at the moment. So we were tasked to look into planetary protection guidelines with a particular focus on the moon, and we were tasked to investigate if there are any shortcomings or any additions required for current planetary protection guidelines or policies that are in place with respect to the future lunar exploration. So just as a recap, really, what is active right now is the planetary protection policy of COSPAR, of course, which most of you should be aware of. So it comes in one category number 2, and 2 subcategories that very explicitly say that missions that are heading towards PSRs or the lunar polar regions, and it's defined as anything northwards of 79 degrees and southwards of 86 degrees, require documentation and a complete inventory of organic material. So everything that the COSPAR PP policy describes is very much focused on organics. Now the question is, how relevant is that for lunar exploration? It's something entirely different for Mars, where we are looking for life. We're not doing that on the moon, so naturally the question comes up, is this complete, or do we have anything else to consider when it comes to lunar exploration? So is it sufficient to protect special sites of interest, right? The lunar poles, and specifically the South Pole, is a special site of interest, and there might be other sites within that region that need to be protected from potential contamination. There's a list of complementary policies out there, so ESA and NASA both follow an approach that goes a little bit beyond what the COSPAR recommends, or is a little bit more explicit in that respect. They require different lists of materials for different kinds of missions in different bins of masses that would be ejected as a potential contamination. But again, the question is, how can this be aligned, and is this complete? And of course, aligning between the agencies worldwide in a global approach would of course strengthen the consistency and also strengthen the guidelines. Now, I want to briefly recap why are we talking about the lunar poles to start with and PSRs, so permanently shadowed regions. Well, it's mainly because of the water that we have found there, or that we know from remote sensing missions that there should be water reservoirs in different forms. The bottom right picture tells you what we think we should expect when landing there and looking for the water. It goes from single molecules in the exosphere and on the surface up to larger deposits in the subsurface that might be meters or even hundreds of meters big, and therefore represent a resource, a potential resource deposit. We have data sets that tell us where these deposits lie, predominantly in those cold craters that are permanently shadowed, where temperatures drop well below 100 Kelvin, where water ice is stable over geological timescales. So that's the motivation. When it comes to the water, we haven't really touched the water yet at the moon, so we're yet to do that. And when doing that, and when sending missions, prospecting missions to the moon to learn more about the water there, we also learn more about the whole cycle that is involved. We call this the lunar water cycle, and I will not go into detail because this is quite a complex chart, but it symbolizes very nicely how everything depends on each other. So we have source mechanisms, we have migration of water across the surface and within the subsurface, and we have potential accumulation of water in those PSRs, and perhaps most likely also outside these PSRs. We're yet to understand really how that cycle looks like, so we need to send missions there to do the prospecting, to do the scientific investigation in order to find out how that cycle functions. And with respect to that, the working group has come up with a list of potential contaminants that would interfere with studying this natural pristine environment. We not only limited ourselves to the organics and the biological contamination, because that has already been addressed to some extent and it might not be as relevant for the moon, although decomposition of products from organic materials will also interfere with the indigenous volatile content there. I want to focus on the third row here, which is volatiles. Of course, when we look for the water and we want to understand where it's coming from, how it forms, we potentially can contaminate that with exhaust gas products, and this of course interferes with our interpretations of the measurements. So volatiles, and first and foremost the water or hydrogen-bearing species, are very important to consider in this context. Inorganic material, metals and oxides, very much the focus of many talks here during this week, is something that we also bring to the moon when we land spacecraft there. Furthermore, we also considered dust contamination or redistribution of dust, and therefore regolith across the surface of the moon as a potential for some type of contamination or at least interference or perturbation of the pristine state of the ecosystem that we want to investigate. And of course, when it comes to nuclear power sources, at some point we also need to consider what happens in terms of nuclear contamination or radiation in the event of a failure or a damage, and how we alter the environment there. So what we came up with as a working group is a set of recommendations, and they have been conveyed to ESA because this was under an ESA contract, and we're currently working on a publication that will be available soon to everybody. The recommendations that we came up with, I just want to briefly go through them if I have the time. We recommend a community-supported classification system. To classify those special sites of interest that we want to investigate and really define what a special site of interest is and why, and what can we do or what should we do to protect that, to inform further guidelines, prioritize early ground truth data acquisition. So with every mission that we're going to send in the coming months and years, we should bring instrumentation to record the inventory of volatiles, to record the status quo, to be able to monitor changes that we induce with any human-made activity in the near future and then also in the far future. So prioritize these early ground truth measurements, also to verify the water deposits and the concentrations and the variability. Use upcoming exploration activities as opportunities, so don't overregulate what's in stock and what's being prepared and what's to come in the foreseeable future, but use those missions as an opportunity to accompany them from a scientific perspective, to monitor changes and measure what's there. Establish an environmental monitoring network. Yes, that's very important because only then we will be able to trace back how we have altered the lunar ecosystem with landings, with human-made surface activity, with mining, for instance, other types of activity that change the lunar ecosystem. And develop a dedicated lunar environmental impact assessment framework, of course, so to bring up very specific points that need to be checked for any type of mission, location, duration, time of landing, time of activity, and materials used. It continues on another page here, extend the assessment and mitigation of contamination beyond only organic compounds. I think this is a point that I personally would like to stress. It's not only about the contamination of organics or with organics and the products thereof. It is about all the contamination that we think is relevant, that I just listed on the page before. And We also recommend developing a strengthened reporting framework, right? So we have a structured approach that everybody can follow in order to share what materials they bring on their mission, what they are planning to do in terms of activity to assess the potential contamination. Develop mandatory harmonized reporting procedures, adapt joint standards. I think that's clear. Standardized reporting is always helpful, not only for institutional missions, but also for private entities. And of course, then think about measures. A potential measure that we suggest is identify certain areas, PSRs for that matter, that we keep in a pristine state, at least for certain periods of time or certain particular locations, to avoid contaminating those while we are assessing the situation and maybe send missions there only later. So this is the entire working group. As I said, I'm presenting on behalf of all of them. The European Science Foundation was represented by Jonas and Alice, and they coordinated the whole work. The report was submitted to ESA internally, and the open access publication in Advances in Space Research, a COSPAR-hosted journal, is in preparation and will be out soon. Thank you very much.
Thank you so much, Philipp. In fact, I knew it. I knew it was going to be you, Clive. We just had a conversation, if not discussion, about environmental impact assessment, as that's one of the points addressed in the draft principles of the space resource activities principles. So yes, please go ahead, Clive.
Okay. Hi, Philippe. It's Clive Neal, University of Notre Dame. I'm going to be a little provocative here. I want to push back on that because to start at this stage, taking permanently shadowed regions at the South Pole and saying that one needs to be left pristine and that one doesn't, you can study that. We don't have the data to make that distinction. So I'm a little concerned about that. The other thing is, if you look at contamination, because we've been to the moon, they're already contaminated, all right? But you're putting contamination in something that's 40 to 60 or 20 to 60 Kelvin temperature fluctuation throughout the Earth, very little energy. And the latest estimates for the micrometeorite gardening of the top 2 centimeters is 81,000 years, and that's sped up from previous estimates, but it's 81,000 years. So are we over-prescribing what needs to be done when the actual potential impact of that contamination is going to be in the top 2 centimeters at worst?
Right. Yes, it's a very valid point. We also stress in that list of recommendations that basically we're lacking data to take any definite decisions right now. This is why I highlighted the point of we need more ground truth. The ground truth is one thing. We need to improve on the modeling aspects as well. We need to understand how basically we interfere with that lunar system. We already see from recent simulations that an equatorial activity can have an impact on a polar site, right? This is entirely different from what we experience here on the Earth, or not so much actually, to be honest. But this is the type of modeling or simulation we need to do in addition to collecting more data. And then keep the discussion, keep the dialogue going, basically. We don't want to prohibit anything, but there's a clear lack of data. We currently don't know how far contamination can reach in certain sites, in certain regions, under certain conditions. So the awareness of this known unknown, basically, is what led us to the list of recommendations there.
Satisfied? All right, we'll continue that discussion for sure at the community Q&A, so please stay with us so that we can continue on that. All right, we'll have now, in fact, 2 speakers with us. From Foley and Hoag, who will delve into how space miners can establish and defend rights to off-world mining resources. So I'm happy to introduce Nicholas Renzler and Jago Chanter, both to the stage.
All right, good afternoon, everybody, and thanks for accommodating two speakers. I'm Nick Renzler. I'm a lawyer at Foley Hoag in New York, and I'm joined here by my colleague, Jago Chanter, where we specialize in international law, natural resources, and emerging technologies.
So we already knew it, but being here and listening to you all, it makes it clear that space mining is happening. The technology is here, and as one of our colleagues just said, the law needs to keep up. So we're going to focus on what companies hoping to explore space resources can do to secure rights to the resources that they find and extract. Okay. So why does this matter? I think as we've probably worked out from some of the other presentations already, your rights are important to stop a rival from trying to exploit the same resources, to plan your operations, to secure financing, importantly, and of course, as I think Kimmel said, to sell something, you normally need to show that you already own it. So put otherwise, security of tenure, meaning that your rights are stable and recognized, is the foundation of any mining venture on any planet. So let's start here, on Earth. So, enormous time and money going into establishing and fighting over mining rights. National legal systems grant things like exploration and exploitation licenses, and these are well-developed systems. Many countries have a complex, multi-phase approach for allowing miners to secure mineral rights. And often that has a constitutional basis. Many countries see the minerals as the bounty of their people and say so explicitly, and then entrust them through these licensing systems to miners who then split the benefits with that country. And then, as we said, it's on the basis of those rights that the miners go and raise money. So moving from that more general description of mining rights on Earth, I wanted to cover two more specific examples that we might learn from. There's deep sea mining, which occurs outside the territories of nation states, so an obvious parallel. That is governed by an international body, the International Seabed Authority, which has proceeded to issue some prospecting licenses. However, now states like the US are starting to consider and are in the process of issuing mining leases to actually allow mining unilaterally due to the authorities' delay in issuing a mining code. So maybe there's a lesson there. The second example is guano mining. This was big business on ocean rocks in the mid-1800s. On that occasion, the US granted rights to US citizens that discovered, and please note that word discovered, because I'll come back to it, a guano deposit, and then took peaceable possession of it and duly registered it with the US government. So now I'll hand over to my friend Nick for the international element.
So as has been discussed at a number of the previous panels, international law does deal with the issue of appropriation and use of space resources. So as most of you in the room, I'm sure, are aware, the 1967 Outer Space Treaty provides that celestial bodies like the moon and asteroids are not subject to national appropriation. But there's been debate about whether mining itself is prohibited appropriation. Looking at the Moon Agreement from 1979, that agreement seems to suggest that private property rights on extraterrestrial resources are prohibited. But there are only a few countries that are bound by it. So the practical impact of the Moon Agreement is quite limited, though if you're a space miner from Belgium or the Netherlands or another party to the Moon Agreement, you need to be concerned about whether you will be able to actually establish property rights. Now, in an effort to resolve the question of whether it's possible to have mining consistent with the Outer Space Treaty, the US in 2020 launched the Artemis Accords, which have since been signed by over 60 countries. And though not a binding treaty, the Artemis Accords effectively interpret the Outer Space Treaty to allow for space resource extraction. by saying that in its section 10, it does not inherently constitute national appropriation. You heard earlier also about last month's meeting of the legal subcommittee of COPUS, where they are starting to develop a set of principles for space mining. Those principles would also allow for space mining, but they seem to foreclose a legal regime that's anything like what Jago described, which involves some security of tenure for those who are investing the time and resources to prospect and extract. So at this point, the COPUS principles have not been adopted yet, but it's important to take a look at how they are developing and for companies that are interested in space mining to get involved with them so that their views are known. But since international law on this topic remains inchoate and underdeveloped, states have begun to provide for property rights, which really arise under national law, to space resources. And that's what Jago is going to cover next.
So, as you probably know, international law is clear that property claims are a creature of national law. And as people have described already today, these are the 4 countries that have really issued a domestic regime governing this. And they differ in important ways. So, firstly, who can benefit from these regimes? In the US, you need to be a US citizen or company, and my colleague has kindly already answered the question on the detail there. Luxembourg requires you to set up a company here as well, but then they have some additional, more practical requirements to really have your administrative operations here. The UAE is a little broader. It offers these rights to citizens and companies, but it's not entirely clear, but it also seems that having a subsidiary in the UAE can be sufficient. And then Japan takes a different approach. It's based on whether you launch or control the mission from Japan, which even, I guess, theoretically lets you try and tag the Japanese regime and one of the nationality-based regimes. And I think the next slide is this slide is probably the most important. So this is about, under these different regimes, when do you get the right to your resources? And this really governs, I think, how close these regimes are to giving anything akin to the security of tenure on which most mining law regimes are based on Earth. So in the US, it says when the resources are obtained. So this is a little less helpful than the US was when it came to guano. Then it was clear that you had it from discovery and peaceful possession. And I think this word obtained, well, I think there's going to be a lot of debate about it in the years to come. It was very interesting to hear Jordan's earlier presentation on planetary defense, because I have to ask whether orbit deflection of an asteroid, would that be enough to obtain the asteroid? If you got the asteroid orbiting another planet or satellite, would that be obtained for the whole asteroid? Well, there's lots of questions. The Luxembourg law is silent on this point, but I think the preparatory materials implied it's similar to the US. In Japan, it's when resources have been mined and you have possession with intent. So there's more detail there, but it's a higher bar and quite restrictive. The UAE uses, again, the broadest language: explored, exploited, or used. I think the word explored is interesting. That speaks to me as the closest to what most mining law regimes work on, where a miner can get rights to what they're investigating while they're investigating it. But of course, this doesn't sit that comfortably with what we've heard about the latest recommended principles from COPUS. And there are also different procedural requirements to secure tenure, which I think we've heard colleagues cover. But following these procedures is important, as it gets the miner the benefit of the property rights under the national regime. So in short, a miner has some choices to make. It needs to be incorporated and based in a jurisdiction that supports its activities, and it needs a regime that gives it clear rights, and at present there are a few options. And all that feeds into the more complex analysis of which regime is best from a financing, from a tax, and from a living preferences perspective, which all go into deciding where to base and operate your company. So I'll now hand over back to Nick.
And what regime you choose or which regimes you choose connect to how disputes that might arise might be resolved. So Jago and I, as international disputes lawyers, have given some thought to the type of disputes that might arise. And in the brief time I have, I'll just quickly mention them and happy to chat with you afterwards. But the first would be commercial disputes. So these are disputes over services like launch or sales that might arise and that where you incorporate or where you obtain the rights to the resources might be relevant. The second would be investor-state disputes. So where you incorporate or under what state's laws you're getting your rights might lead to a dispute with the government of that state. Then there are state-to-state disputes, which might be disputes over liability or rights in space. And then finally, and I think the colleague from the Sorbonne mentioned this earlier, but disputes that implicate minors' access to resources and how rights arising under these different national systems might be resolved. Those disputes might be the most consequential ones, but it's not fully clear yet how they might be might be resolved. But that's exactly why Jago and I think this is such an interesting area. We're privileged to work with many colleagues very experienced in international law, and it's clear that this is going to be the next frontier of development in space, the resolution of disputes and the security of tenure to space resources. So we're happy to answer any questions now or later or during the community Q&A, but thank you for your attention.
Thank you so much for that presentation. I don't want to take up any time and head straight to a question from the audience. The light is too strong.
It's me.
Yes, Gunesh, go ahead.
Yeah, hi. Hi, Gunesh Unnivar, University of Exeter. Happy to see investor-state arbitration, I suppose, being referenced. I also do ISDS. So I have a question specifically about jurisdiction, which you may have seen coming. How do you overcome the jurisdictional hurdles? Do you focus on the country of incorporation, or do you actually look at the territory, in which case, how could we establish jurisdiction where the activities take place on a celestial object?
Right, so the question is basically, would extracted space resource or right be considered an investment because it's not physically in the territory? Is that what you're thinking about?
Would it be covered by the jurisdiction of a bilateral investment treaty, for example, as per the definition of an investment?
Yeah, certainly I think there's arguments on both sides, right? So the argument is, well, if it's not in the territory, it's in space, there's no jurisdiction, but the rights are arising under a national law, right? So you could say that the right itself is a property right, that it's inchoate, but it exists under that national legal regime, and therefore it constitutes an investment. There might be also permits or licenses that a state might issue, which would also be relevant investments. I don't know if you want to come in here, Jago.
I'd just add that I look forward to this. I look forward to all the arguments as to what territory means in these contexts. We see this in a lot of our cases. In the end, you have to say, look, it's the wording of that treaty, like any contract, treaty, read in context with the rest of the treaty, etc. What does territory mean? I would anticipate there'll be arguments based on the fact that under the Outer Space Treaty, the launching country keeps liability. I think I could see people trying to use that in the context of, arguing that it's within the territory. But obviously, I don't think we've seen these cases yet, but I look forward to them and discussing them as well.
Thank you.
All right, perfect. Thank you so much. I look forward to that too. All right, thank you. One more round of applause, and then we'll continue on. So we have our last speaker here from the International Space University in France, who'll talk about the legal and policy frameworks for equitable and sustainable lunar ISRU governance. Ruchira Huchgol, it's nice to see you again. The floor is yours.
Hello, loud and clear for everyone? Okay, so.
No, we're not yet at the community Q&A. One more presentation. Thank you so much. We're going to be there very soon. There we go. Thank you so much.
So, hi everyone, I'm Ruchira Huchgol. I'm an aerospace engineer now transitioning into space policy, doing my master's at International Space University. I'm going to take a bit of an ambitious approach and present a three-phased framework here, which is based on the ideation to bridge the gap between the existing framework and the current state of the art of the industry. Bear with me because the framework is a bit nascent and I'm open to your suggestions, feedback, and critiques. So let me introduce you to the paradox. If we take the last year's Q4 results in terms of investment, the space sector has seen a record-breaking cash flow investment of $12.5 billion. So we see that there is a capital flow, we see the technology is maturing, then what is the bottleneck? The problem, I personally think, is the governance vacuum. One of the reasons being the traditional investors look for the 5 to 7 years exit plan, but ISRU is a niche of a niche, and it is a long-term goal of 15 years or more. Then there is the insurance vacuum. Most of the big insurers also say that they would not underwrite the big lunar ambitious missions until they have liability or proprietary rights established. What does this do? It creates the market mirage, where we have great potential, high demand, but a bit of lack of accountability. I believe we are seeing a capital allocation problem as a technology problem, and this framework answers that particular question. So my framework is based on 3 pillars. First pillar being the legal trigger. I go back to the Moon Agreement, fulfilling the appeal to develop an international mechanism, which will then help us enable the ecosystem for lunar Earth system. Because I believe we are now moving from exploration phase to utilization phase. Pillar 2 is operational, as it aligns with the global space exploration roadmap, specifically the lunar phases, which complements the robotic, habitation, and sustained present laid out for the future. Pillar 3 is institutional, as it aligns with the ESA Space Resource Strategy campaign phases, where we see a trend where we are moving from grants to more of a private contracts. Now, I have designed this framework taking into consideration the stakeholder wheel, which has the regulators, agencies, government, private sector, technical experts, operation managers, UN delegates as well, to bring in more inclusive overview, and takes into consideration the landscape of the market, which is now moving to private investment. This is the framework I proposed. Phase 1 is operational, which is now current. We use the existing frameworks that we have and the current state of the industry. In phase 2, we use all the work that we do in the next 5 years to create the heart of this framework, that is the adoptable governance, and which will help us to move from the investment, which is now stuck in R&D, to more of a commercial scale-up. In the phase 3 is the circular economy 3.2. Once we achieve both the phases, we can then start focusing on integrating the AI advent, integrating ESG, as well as creating a sustainable ecosystem. Let's go into the details of phase 1. Phase 1 uses the existing treaties, as I mentioned, and the soft laws that we have, like the Artemis Accords, which help us, particularly the private sector, to overcome the valley of death and sustain the TRL levels of 4 to 5. In this, the key active stakeholders would be the private companies taking the maximum risk, of course, technical experts sitting with the engineers and scientists deciding the have and the have-nots, government officials still acting more of a facilitator, and the UN delegate as an observer preparing for the phase 2. In this phase, we are at the stage 1, more or less called prospecting of the ISRU value chain. Phase 2, I call, is the institutional maturation, where all the work that we do with the transitional bodies, that is the pillar 1 of this phase, is used to develop the pillar 2, which is the adaptable governance. We use the famous abbreviations that you have heard so far for the 1.5 day, that is the ATLAC, the Corpus Working Group. We have the OECD Space Forum, then UNECE, which is the resource management, and the ITU's SFCG. We use their foundational work to develop the adoptable governance, which has 4 main bodies, namely Lunar Ecosystem Hub, Cislunar Environment and Radio Registry, Lunar Arbitration and Mining Registry, and last one would be even more ambitious, but as I've been interacting with the private sector and the founders here, I think it is the need as we progress, which is the Lunar Space Board Exchange. Now, the lunar ecosystem would act as a body overseeing the work of the rest 3, and create review cycles to maintain and make sure that the framework is aligning with the technological readiness level as well as the maturation of the market. The Cislunar Environment and Radio Registry would take the inputs from the ITU SFCG work, making sure there is orbital allotment and frequency allotment as well. Then we have Lunar Arbitration and Mining Registry. Here they work in cohesion with the resource management to generate a framework where they can keep a track of who is mining, what they are mining, and how much, and give them a compliance certificate. Then the Lunar Space Exchange Board. The ideation came because I believe the investors and the insurers need to know what is the hot topic in the market right now, so they can keep the tabs of it. All of this will then help us to achieve the pillar 3, which is the market initialization. In this, the regulators will take the lead, investment directors will pull the money, becoming the engine of this phase, and insurance providers will provide the shield. This will help us to move into the stage 3, resource processing and surface manufacturing of the ISRU value chain. Once we achieve this, we move into the phase 3, circular economy 3.2. Now we take into consideration the advent of AI, where we can use the live telemetry data to keep a track or create or look for evidences in terms of liability or resource claims. Then we have waste management and sustainability, where we integrate ESCG and the similar mechanisms like space sustainability ratings. Achieving this will help us to sustain a market maturity, where we have our first market buy-in, a part which is not a space agency, but an actual customer, which will then help us to establish this closed-loop lunar Earth ecosystem. Here, the active stakeholders, I personally think, would be the UN delegate, because this stage is where we can actually start talking about the equitable benefit sharing. And we would be at the stage 5 utilization. Of course, I've used the advent of AI to create a case study, and there's a lot of stuff here, but I'm going to quickly run you through the case study. There is a company called X, which is based in Luxembourg, has a lunar oxygen extraction TLR level of 4 to 5, okay? Today, they have a seed funding, they have all the existing treaties, they have the soft laws, but the problem that the industry is facing, that after the seed funding, they are unable to get any of the series A, B, C, D. Why? Because investors are like, too risky. Do you have anything alternative? And so after talking to all the private companies here, I realized they had to make a pivot. They had to choose a terrestrial approach as their main function and say that ISRU is a future prospecting. If so, you don't have my phase 2 or phase 3, the company gets stuck in the phase 1. So now, the company, assuming has all that they need in the phase 1, moves to the phase 2. Now they have my adaptable governance, heart of my framework in place, where they get the compliance certificate, where they get the regulatory security, and the investments is series A to B that is needed in order to move the TRL level from 4 to 5 to at least 8 to show that this is happening and achievable. Once that happens, and we move to the phase 3, now the company can move towards another TRL levels, more funding, maybe until Series D, and then actually can create a customer apart from a space agency and create a stable market for a lunar Earth ecosystem. So I've explained the framework, I've highlighted it using a case study. Now, I would answer the question of why. I believe the economic multiplier is quite high. We have a market revenue projection of 17 billion euros, provided there is a regulatory certainty, okay? Then they say there is a strategic saving of 54 billion euros for end users, 1.8 employment opportunities, as well as 2.5 billion euros for terrestrial in terms of utilizing the lunar tech. Now, if we want to materialize all these numbers, we need to have a regulatory framework that actually assists the ecosystem. So I would say we see this shift where agencies, correct me if I'm wrong, or would see this trend, that agencies are now moving from an architecture to more of a facilitator or a regulatory point of view, and private sector is coming to become the ones that are actually going to do the work. So I believe the time to start thinking of phase 2 and phase 3 is now. And I know the framework is a bit futuristic, must have caused a lot of speculations, but I'm open to take the questions, and thank you for your time.
Thank you so much for that futuristic proposal, but still I think important and relevant discussion to open up for. Do we have questions before we open for the community Q&A? Or is everyone ready for the community? Yes, please, go ahead.
So congratulations on designing a framework to meet a requirement that has been coming at us for, I think, 5 years. Do you see this, who do you see this as your customer?
Sorry?
Who do you see as your customer or your client for this framework?
As I said, this is very nascent, and I'm still developing it. But I clearly understand that it is not realistic at the given point of time. But if I, coming from an engineering background and now transitioning to space policy, and also having an experience of analog mission, understanding how an actual space mission works, I believe if I'm able to just pivot the conversation that we need to take into consideration what are the obstacles or hurdles for a private sector to evolve and achieve all that is there on Moon, if I'm able to just push in the conversations in the initial 5 years, I think I've made it a successful pivot. Yep.
Thank you.
All right, thank you so much. A round of applause to you, but in fact to all panelists. So now we're moving on to the community Q&A, and before we start, I'd ask Antonino Salmeri to please join me here on stage. He's not only director of the Lunar Policy Platform, he's now also, if I may say so, a consultant with us at UNOOSA. So a round of applause to Antonino.
Thank you, Rosanna.
We couldn't be doing what we're doing without you, especially all the work going into ATLAC. It's riding on your shoulders. No pressure, yes, exactly.
Right.
All right, but now I believe we did have, and please, Antonino, take the microphone whenever you want, but I'm happy to kick this off. I know that we didn't have a separate panel just for this panel, but this community Q&A really is for both panels, panel 1 and panel 2. I believe there were a lot of raised hands at several of the presentations given. It's now, now's the chance to ask your questions, and please, it's for everyone to sort of take the floor and answer it as well. So I know those of you with microphones, you'll have quite a hard job in front of you, but we'll make this work. All right, yes. Please, I see a question in the back already.
Hi, Michael Castlemiller. Actually, I wanted to ask Neha a question, which was by the way, fantastic presentation. I thought it was the clearest explanation of that process that I've heard. So I wanted to ask, it seems like is it streamlining the process for companies to also clear all of those other regulatory requirements that other agencies have? In other words, is it like I submit my application to Office of Space Commerce and then it goes, like they take it around to all the agencies and get all the approvals and stuff for me? Is it like a one-stop shop like that?
So that is correct in part, with the caveat that if you need other licensing and authorizations, those remain in place, right? So this is focused more on the novel space activity side of things. Also built into the proposal, which again, we don't know how it will be implemented, are certain waiver options for the different agencies. So for example, the FCC could possibly look at it and say, hey, we'll waive the space debris rule for this particular activity. So there are a lot of benefits for a novel space activity operator to go through this process. And I think that's what the Office of Space Commerce is hoping to achieve, is providing these few carrots to the operators and still having to get their other licenses, but then going through this unified single application process. Again, with a hard cap of 180 days to have a decision issue, I think it's fantastic.
I actually have a follow-up. So if you could stay the mic with our speaker. Thanks. So thanks for the presentation. And we also heard, as Rosanna mentioned, Gabriel Sweeney talking about this at Copus. And so I asked him the same question. I'll repeat it to you. For a process that goes so fast, 180 days, there may be a lot of open questions that will be left later on for supervision, right? Because Article 6 is not just about prior authorization, it's also continuing supervision. So I'm wondering, how do you view the potential risk of authorizing something that then you don't know how to supervise, for example?
And again, I can't speak for Gabriel. I know that he's, he's the mastermind here. But it seems to me that they wanted to do a light touch requirement on everything. And even if you look at the supervision provision in the proposal, it's simply done by attestation. But at the same time, having a confidence in all of the agencies and their review of these, these applications where, you have the option to do the 2 30-day extensions. And I feel like they are going to avail themselves of that because they will review it for national security concerns, for dangers. So I think we will be well covered. And again, you have a lot of confidence in those agencies to do the things they need to do before they authorize and then continuously supervise. And I think I have to say something that Dr. Phelan mentioned earlier, right? Like it's an iterative process because we haven't actually put any of these novel activities through the ringer yet. So when we start doing that, we're gonna start understanding the granular level and the details of what we need to do for each particular activity and then start classifying those activities in the future for different types of authorization.
Thank you.
You can keep the microphone. I have a question for you as well. Also for Neha. Miles Tempe from the Swiss Institute for Advanced Study. I have a question about the environmental impact, assessment. So I noticed that it's not one of the 4 grounds for denial, but like a specific use case comes to mind, which is reflect orbital, which could have a catastrophic environmental impact. And they're doing that right now through, I think, the FCC. So is that in the framework or?
So it's not directly in the framework as far as I can see, but if you look at the 4 grounds of denial, they're pretty broadly phrased. It includes, international obligations of the United States, whether it would negatively impact its international obligations, foreign relations, whether it would negatively impact or endanger any U.S. government space missions, right? So if what you're saying could possibly fall under any one of those categories, and it's going to depend on the agency that's reviewing the particular condition or requirement.
Neha, sorry again. If there are cross-agency licensing requirements with the conventional licensing obligations and the department's novel licensing, which would take precedent, or if one was denied or caveated, what's the discussion or resolution process would you imagine might emerge?
So I think what you're asking is if an operator chooses to go through parallel routes, like doing the novel space certification and then doing the separate tracks and trying to get their novel space activity through that way, or?
Well, say if there's a NOAA requirement, I mean there will be an FAA, perhaps a launch licensing requirement, and then also this. Are there potentials for conflicts between those aspects?
So I think that's where the interagency review will come in. The proposal is also very specific on what each agency has to provide if they're going to raise an objection. And if that objection can be mitigated somehow with the imposition of a certain condition, then I think that's what the Office of Space Commerce is going to ask them to do or look to do. But it's very tight in terms of denial. And again, that's a great thing for operators.
Yeah, Jim, just to follow up, this came up also during the discussion at Corpus with Gabriel. And so I think you clarified that because this is not done by legislation, they cannot alter the competence of the other agencies. So they could do this kind of speeding up process. If the certification goes well, there is no objection, great. But if other agencies want to add more requirements, they can do so, and the office cannot stop them, right? So in a way, this could still become cumbersome if some of the other agencies don't feel satisfied with the level of review that has been done. And if there isn't disagreement, as was said, it's going to go to the interagency process. But in the end, because the competence of FAA, FCC is established by law in Congress, and they don't have legislation behind this new process, they cannot change that. So it will stay there until there is a new law. Also, if we can lower a bit the lights, I don't know, I'm blinded, I don't see anybody in the room.
Yes, and I was just asked that when the panelists answer a question, it would be great if you could come on stage, because then we're able to see you on the big screen as well. Just read about it. All right, let's continue on with some questions. I mean, I saw a lot of hands when we delved into planetary protection. Clive, you're up.
Okay, Clive Neal again. I saw, again, going back to Philippe's talk, an environmental impact assessment for the moon. Can you give us a bit more detail about what that entails and why you are proposing it?
Yes. Hello.
Join us on stage.
Would be fantastic if you could join us up here. Thank you so much.
Okay. So we came up with an initial set of ideas, right? The details aren't carved out yet. This is not the job of the working group, I guess. But I think the simplest thing that we already have in place right now is a declared list of materials, right? So this is already a good starting point when it comes to assessing the potential contamination and the consequences thereof. I think it's more important to go more into detail and think about, assisted by the modeling and new ground truth data, look into other special temporal impacts that we need to consider. So different times of landing that we could tolerate more than others, or different types of landing corridors, or different types of keep-out zones. So I think we came up with a list of aspects that we think would be worthwhile investigating in closer detail. So gaining more knowledge about the locations, the resources there, the volatile inventory, and how that changes spatially and temporally, really. And then also to look into the potential exhaust gas products of certain engines, for instance, look into the chemical decomposition products, how they would interact with species that are already there, and so on. So it's a whole list of things we still need to do and understand in order to really assess contamination at the level that we are interested in from the scientific perspective.
Yeah, go ahead.
If I can clarify, get a clarification. So you are proposing to get data to inform a regulatory framework, i.e. an environmental impact assessment. Because I don't think we should have one in the principles that are coming out of Stephen's working group because it's too nebulous. We don't have a baseline in environmental issues on the moon, environmental data, nor do we have the natural variations. So I really support your environmental monitoring because that is needed now, because we also need to understand how quickly that environment can recover. Because that's another thing, is we are making a lot of assumptions on the basis of very little data. So I applaud you for getting, putting a spotlight on that so we can get the data to create that enabling framework.
I know this is quite a controversial topic in a way, so I want to seek the views of the room, make this a little bit more interactive. I'm wondering, who agrees with what Clive just said, that we are fine with just environmental monitoring? Can you raise your hand if that's what you think it's enough? I see 2, 3, plus yours, Clive, of course. 5. Okay, 5? 5 people. Who thinks that we need to have more than that? That we need to have a precautionary principle or things like that on the moon? Okay, I see more hands.
Why? Why?
Why?
That's why, educate me, why? Why do we need it?
Someone wants to take the mic? Yeah, Chris Johnson.
He was in the first group.
Chris Johnson, and I almost said Chris Johnson Secure World Foundation, but Chris Johnson, Leiden University. So yeah, there's this obligation, the precautionary principle should apply. You can argue that it does apply. But does that mean that the requirements rise to the level of an environmental impact assessment, even though we don't know how that would happen, and it's incredibly onerous to make that happen, and burdensome to make that happen, and we have no baselines to make that happen? So therefore, an environmental impact assessment of the impact of your activities, as you say, would be very nebulous. There must be some distance, some connection between the fact that environmental law does apply, and there should be some type of cognizance of the impact that your activities will have, but what we have, the EIS, these impact assessments on Earth, is, as you say, quite burdensome, nebulous, comprehensive, almost impossible to complete. He says it's irrelevant for the moon.
Well, for what we're doing on this planet, there's a lot of biodiversity down here. But is that, we don't need to worry about that at the moon. So it comes back to, we have a lack of data to adequately put something in there that is meaningful, because we don't know the baseline of the environment. We don't know the rapidity of recovery of the system. So, and we don't know the interactions of persistent contaminants on the ephemeral lunar science that could be ruined. All right, and so it's this, I don't want to see a very restrictive reactionary policy that's gonna disable us from getting those data. That's my whole point here. We're reacting in an absence of data.
Thanks, Clyde. I think we got a few hands now, so the topic was good. We have our speakers first, then first row, then we have a gentleman there, and then we have someone here.
Okay,
Jim, yeah.
Maybe I can just comment to Clive. So we have a lack of data, absolutely. I think we also have a lack of awareness what types of consequences we need to consider. Because we are just about to learn more about the moon. We know that there are known unknowns, but also unknown unknowns, right? So I think it's absolutely about the dialogue, also with private entities, that they have this awareness and they come up with this list of materials that they bring to the moon that we as scientists can work with. And I think it's not yet about imposing restrictions at this point. It's more about the general awareness and thinking about taking stock, basically, of what we need to learn.
Thanks. We got, yeah. You want to come on stage? You're a speaker.
No, I have a question for Dr. Freeland, like from part one, right? You mentioned something about benefit sharing and how sometimes it's pegged onto like monetary compensation. My specific question to you is, in your leadership role at the working group, have you come across any sort of narratives where private sector was concerned about their investors, or wherever they're getting capital from, their due diligence and any expression of concern regarding, hey, is this going to be something that's going to be money out of our pocket if the international community decides that it's got to be monetary compensation of some kind?
Oh, 1 second. I wanted to stay on the environmental part, so I don't know if the other comments were on that. So we close that thread and then we go to a new question, if that's okay. Yeah. So if that's on environment, yeah.
Yeah, sure, it's environmental. It's a landscape that gets bombarded for the last billion years. So my perspective as a lunar resources registry is, how do I stimulate economic activity? How do I prove there's assets there? But proving that one has to do a lot of environmental impact assessments on a zone which is blasted apart anyway, it seems a bit too much from an investor perspective. If you want more environmental awareness on the moon, you need to fund more missions to the moon, not trying to stop them because they might cause damage. So it's a bit of a cart before the horse scenario. And this deadlock needs to be broken. Otherwise, nothing happens and the moon becomes like Antarctica. So.
All right, thank you so much. Some people may want the moon to be like Antarctica, but not everybody in this room, I guess. Jim, were you following up on environment, or was something else?
It was just more a quick comment. If you look at certain continental clusters of countries and what happens to their economies when they over-regulate, especially in this technological age of advanced progress, one might argue we are in a golden renaissance age, or entering into that, where we have to distribute that prosperity more evenly, but still a renaissance. We need to move forward rapidly. And I think just the comment I want to make, it's not a question really, but a comment, that we should also take a context of the bigger picture of what we are doing and the responsibility we have at a generational level, and how we might need to crack a few eggshells on occasion, not without responsibility, but we do need to move forward as we want to try and regulate, but we shouldn't regulate in the context that we regulate with terrestrial environments where we have millions of people living in urban ecosystems, et cetera, and there is a difference. And as I think, as Simon put, the moon has got pretty hammered already. We ain't going to do much more damage to it, but we do want to make sure we're taking that scientific moment to measure, to assess, to record, and then to progress.
Makes sense.
Sorry,
Rosanna.
Stephen, can I just briefly say something on what Jim said, and then please do answer that benefit sharing.
I also want to speak on the environment.
You also want to, just very briefly, Jim, if I may, I fully agree. Overregulation is something we really need to be careful about. But I think when it comes to space, we're nowhere near overregulation at this point. And from my personal experience as an office that assists countries in drafting their regulation, we have industry come up to us, I would say nearly for sure weekly basis at this point, saying, but we want regulation. We don't know what we should do. And we have all these plans, but investors won't invest, and we have we have issues with insurance because we're needing this minimum regulation, which we don't even have yet. So I think the point on overregulation, I get it. Especially looking at some other areas beyond space, but we're not quite there yet from what I experienced. But please.
Go ahead, Stephen. Come on stage, yeah. There is also a question of accountability, right? If I can use the time to follow up. As you said, Jim, right? So it's true that we don't want to overregulate, but also we don't want to have a free-for-all on an environment that everybody feels very attached to. So I think a lot of people that I talk to in general about lunar governance, they're really worried about repeating the mistakes of the past, from colonialism, from over-environmental exploitation, tragedy of the commons. So I think if we also want to keep our case with the public, we should go and say, we don't know, admitting what Clive says, but also we're not just going completely blindly and doing whatever because we don't know. So we need to find that sweet spot. And maybe Stephen has the answer for that.
Thank you. So I'll talk a bit about the environment and then answer your question, Neha. Thank you. So this is raising exactly the discussions that we have at the international level. And you have different perspectives about the way we should approach. And by and large, they differ. I'm really generalizing. But by and large, they differ between those that perhaps see themselves as having capabilities and those that don't in the foreseeable future see themselves as having capabilities. And there you have, on the one hand, those with capabilities say, well, look, let us do it. We'll, as we learn more, we'll, in this iterative approach, work out the appropriate levels of, if I may use the word protection, environmental protection. That's maybe not the right word. And you'll see in the principles which reflected the views of those countries as well, there's stuff about environmental impact. There's stuff about let us get on with it and then we'll see. On the other hand, you've got those countries that take a precautionary approach by saying, well, hey, space belongs to all of us. I don't see any real tangible benefit to us in the short to medium term. And they see it a bit like a neo-colonialism approach to space. Now, one might argue that both sides of the equation are vested interests and emotional responses, and the job that we're currently engaged in is trying to find a balance. And you might think it's impossible because they're two separate extremes, but I think even on this issue, we will find a balance. The reason environmental impact assessments were included in the first draft is because many countries called for it. And now the reason that it's being, we're looking at it in different ways because there's been a reaction from those other countries who say, as Clive argues, that this is totally inappropriate because you can't. It's putting the chicken before the egg or the cart before the horse, as you said. Yeah. So in a 10-minute, 10-minute, you see the complexity, and our job is to simplify the complexities, but you can't ignore the fact that there is complexity, and we have to make sure that every one of those views are heard, because if they're not, you won't get compliance and you'll get resistance and all that, and you won't get consensus, and then work it out from there. But I think on the environmental side, we'll find a way, right? And then in 5, 10, whatever years, there'll be another set of principles or something else that will build on that. On the issue of benefits, thanks, Neha. So there was a proposal, and it's in the latest draft because it was just put in by, in that case, by Brazil, which talks about financial benefits being distributed. And whilst I don't want to go into law too much, there's a comparison between the Moon Agreement about space and the Law of the Sea Treaty about the deep seabed. And in the Law of the Sea Treaty, it says, hey, you've got to share the financial and other benefits to digging up the deep seabed. And that was, as I said in my remarks, an absolute red rag to a bull. And those that had the capabilities just didn't sign up to the Law of the Sea Treaty, and they had to find a compromise. In the Moon Agreement, they'd sort of said you've got to look at the equitable sharing of the benefits. And if you recall my remarks this morning, you know, that gives you the possibility. There are benefits in so many different ways. But yes, when this proposal now from Brazil, which, if I may say, probably won't be reflected in my consolidated draft, but you know, they're entitled to put it in there so we all see it, has talked about sharing of financial benefits. What is that? That's politics. As I said this morning, there's a broader movement within the UN movement generally, but it comes into space where the less developed countries are fighting back and saying, we've got to share benefits, we've got to share benefits, we've got to share benefits, and they're being a bit more, aggressive in the way that they're doing that. Again, we just have to find a compromise. I mean, that's why the system will, you know, in the end, nobody will be completely happy with what we have, but if we can find the things that we can agree on and find a compromise. And so there will be a balance. There will be language, Clive, that says the environment's important. And it is. And you can understand the view of some that say, hey, space belongs to all of us, you know, in this generalized term. These guys are going up there, they're going to wreck it, they're going to take it all for themselves, you know, and there's a philosophical, ideological resistance to that, which then manifests in words about, you know, restrictiveness. And so we just have to find a way, and any ideas are great about compromises, but that's, in a sense, the beauty of this system, even though in the end, you know, nobody will be happy, but everybody is prepared to go along with it, and they've all seen that their opinions have been heard, and they've all had the opportunity to contribute, and they all feel a sense of ownership. But it's not, you know, if we all wanted to work out which restaurant we're going to tonight, you know, we'd all have different views, right? And you'd want to go to the Vietnamese restaurant, and you'd want to go to the Luxembourg restaurant, and you'd want to go to the French restaurant. And in the end, we might end up going to, heaven forbid, the Australian restaurant, right? As a compromise, you mightn't be entirely happy, but there's no way you wanted to go to where Clive was suggesting, because but in the end, if we can all reach that process, you know, and then recognize that we can build on it. You know, this is just the initial phases of principles. That's, you know, the important message that I want you to take away. Nobody is trying to shackle anything. But you have to understand there are many perspectives on these activities, and you don't want resistance. You don't want Brazil, which is then part of BRICS, which is a big country, you know, saying, well, we don't support this process, we're going to make it extremely difficult. And you don't want the United States and, you know, Canada and UK saying, well, you're being too restrictive, we're just going to go ahead without it, you know. Remember my scenario about the 3 different groups having 3 different sets of rules in close proximity. That is a disaster we have to avoid.
Thanks, Stephen. And in the doubt, go to an Italian restaurant, I guess. In the doubt, you can go to an Italian restaurant. Okay. I know Jim has a point. I also want to invite all the other panelists who has another chance to speak. If they want to raise their hand and make any comments, please, we'll be welcome to hear from you. Jim.
So I had a bit of a different question. Just actually raised on by Stephen's point. What's the position of China and the ILRS countries in all of these deliberations that are going on at UNOOSA, maybe about space resources or about space law in general, on these new ventures and the new mobilizations?
I mean, I can briefly touch upon it from a UN perspective, but of course, noting, we serve all UN member states. The positions but they're public. They're open to the public, of course. But I think, especially for the ILRS countries, an important point, and you might or might not like to hear this, is really oversight around commercial ventures and commercial operations, right? It's based on political reasons, as you know. It's based on historic reasons as well, and a big focus that we see, Stephen, and please do add something in regards to the principles, is of course this issue of authorization and supervision. That really continues. That it's clearly there also for space resource activities. And one more point I want to make, and I think we didn't hear maybe enough about it throughout some of the presentations, and I think, Stephen, you would agree with this point, is, a space resource activity is inherently a space activity from day one. So the treaties that we have since the 60s, they're applicable anyways, right? Now we just want to understand how much more do we need to know to make these activities even safer, even more coordinated, going forward. So I think that's really the key point that I would say the Chinese delegation has, the Russian delegation has, and several others that are like-minded, is to ensure that these key provisions, authorization and supervision, for example, of commercial entities or non-governmental entities, that really gets reinforced.
That's what you meant by oversight, was that they maintain an access to that visibility.
Exactly.
And following on what Rosanna said, right, Jim, and to your point, positions are public. So if you go and look at the reports of the legal subcommittee over the past 10 years, and you see how the positions have evolved, there is no specific reference to any country, but you can find the statements uploaded on the UNOOSA website, and you can read that certain positions have changed in time. So if you go to 2016 or 2017, 2018, which is, for example, when I started going to COPUOS, you would hear some delegation express the view that unilateral regulation of space mining is illegal or against the Outer Space Treaty, that for space mining to be legal, you need international regulation, you have to do it under an international authority. Those positions have softened through time, and I don't want to point fingers at any delegation, but some of the ones you mentioned, they also have changed their position and became much more open to the idea of, yes, this is permitted under the Outer Space Treaty, but the question, as Rosanna said, is in the how are we going to do it, and how are we going to authorize and supervise it, how are we going to maintain the obligations that we already have and make sure that this does not become a free-for-all. So China made a submission to the working group a few years ago, which is quite interesting, and I would recommend reading that because it really outlines their perspective, which is not so far away from what we've been talking about today, perhaps taking a little bit of a more cautious approach than some of us may have.
But maybe if I may add one more thing, and I think it really goes to show the hard work that Stephen has been doing. But Antonino and I, we know working methods of COPUOS very well. We work directly within them. And I have to say, for the Space Resources Working Group, and knock on wood that it will continue, there is interest of everyone to make it work. That's what we feel in the room. And you don't always feel that necessarily with every topic being discussed. But when it comes to space resource activities, there seems to be a strong buy-in, I would even say, from every delegation across the geopolitical spectrum. And I think that's really positive. That keeps me very optimistic for the future, I would say.
More questions.
I'm holding the mic and I want to ask a question. As Professor Catherine says, resources are resources because they have a use. We are talking about space resources, but I want to ask a particular question. Maybe this is not a perfect question. It's regarding in this new era of new space, there is a rapid growth of space race, and there is huge space commercialization going on, and we have space race between various countries. And another huge problem is space debris. So we have a lot of space debris and we have a lot of things going on in outer space. If we want a secure and sustainable space exploration in upcoming future, so who will be regulating those vertically integrated companies, or let's say companies such as SpaceX, if they go on launching like this, like in full scale, maybe in a week, if they launch 10 or 15 times, so who will be regulating them? I mean, who will be looking after those particular space debris problem? I mean, who will be looking after the regulatory aspects? Like if you launch certain amount of your objects or your spacecraft, you should be viable for this particular thing. So is there any international regulatory body who will be looking after that? Because we have to look for our offsprings for secure or sustainable space exploration. So what will be the positive of this space race, or let's say commercialization of space, or what will be the negative impact that we will be having? That's my question.
Thank you, and I'll take it very briefly because I want to hand it over to panelists, and Antonino, if you want to add something. But we should discuss this at a space debris conference. So space resources is just a mini subset of the work we do at UNOOSA. Space debris is a large one as well, and space safety specifically. And of course, regulation happens nationally. And I think Neha, she will be able to tell us how it works within the US, and others. Stephen will tell us how it works in many jurisdictions, including Australia. And of course, we have non-legally binding instruments such as the space debris mitigation guidelines, the long-term sustainability guidelines that get implemented nationally, more and more so. To get a license to operate a satellite, you need a debris mitigation plan, you need an end-of-life disposal plan. Things are being done. But what is missing, and I'm just saying this to say we're on it, is space traffic coordination, is to make sure we don't create more debris through collisions that are avoidable. So that is another track that COPUS is really working on hard next to space resources. It's really space traffic coordination and making sure that all of your activities that are planned in coordination with other commercial, and that's the main point here, commercial and institutional operators. But yes, not space resources related necessarily, although not entirely unrelated either, because we do not want to leave junk on the moon either, right? So yes, anyone want to add something on this or make a different point or a related point?
We're almost at the end anyways, right? So just one point on this topic, right? Because I also sense that perhaps your question, in addition to what Rosanna brilliantly said, is whether we can use debris one day as resource, right? And in that sense, it's important to remember that, as you have a sticker about it, once a launching state, always a launching state. And
Stephen's words.
Exactly. And so in that sense, human-made objects will continue to remain the liability and responsibility of those who launch them into outer space. And so it's not going to be qualifying as a space resources, whereas something else that we may want to consider as abandoned or transferred then could be an interesting case of like mixing it with local resources and manufacture something. There is some spacecraft on the moon that already are destroyed. You could try and look it up if you can take it, but you will need permission from the country. Any other final points from any of our speakers, panelists, friends?
Yes, please, Stephen. Do you want to join us?
Just to make the point that Catherine, our wonderful host, made the other day. There was a question yesterday about byproducts in space. And remember what Catherine said? It was a great answer. She said, there will be no byproducts. We will need to use everything, anything, I think she gave the example of separating oxygen and there was metallic byproduct. We will have to use that for something. I was once at a talk where somebody was talking about, well, the first space resource activities will be digging, moving regolith and then doing things with the regolith and all that. And I asked the question of the presenter, this is maybe 3 or 4 years ago, if you do that on Earth, you have slag heaps, right? So what's the percentage of slag is that the right way you say it? Percentage of slag that you have in an operation. And this person said, well, maybe 30 or 40%. And, you know, I was outraged, as was everybody in the audience, and this gets back then to the emotion of the environment. And your narrative is so important, therefore, if you're engaging in a space resource activity and you say, well, we're going to have a 40% slag, you know, and we don't care about it, you're going to get a lot more resistance out of that. And that's why I thought the answer that Catherine gave yesterday, I don't know whether you're in the room, Catherine, just made it clear that, you know, that thinking has now been refined, if pardon the pun, that thinking has now been refined, and it's important that the impact on the environment, no matter what you think about, you know, the moon, and I take the point, but no, you know, is minimalised. The adverse impact is minimalised. Otherwise, you know, that really does raise some issues. Sorry to interrupt.
No worries. Thanks, Stephen. I think we have come up to the end of our time. So first, I want to invite another round of applause for all our speakers and interventions. I think this has been quite an interesting discussion. You know, in the opening yesterday, Catherine reminded us of the very beginning of this conference. I had the lucky and the privilege to be there, even before it was in Luxembourg in 2018. And I will tell you, back then, there were only 2 lawyers in the room. It was me and Professor Tanya, and we got each 90 seconds and 1 slide to talk about the legal aspects of space resource activities. So things have changed. We have a full session now with over 10 speakers, excellent colleagues. The UN is doing so much work that we're very happy to promote and support. So I think there has been no better time to be a space lawyer and to work with space lawyers. So thank you all for your contributions today, also from my side. And yeah, we'll see each other next year for more legal and regulatory discussions. Rosanna?
Absolutely right, Antonina. I remember those slides, I think. I'm pretty sure I was there. And of course, we have to say also, with the lawyers in the room, we have a different sort of elegance in your outfits. You bring such wonderful, and I know you care about this, Antonina, because we've had a long conversation about this, materials, etc. So if you want to talk about clothes, we can also do that. Thank you for being in the room. Thank you for everything. It is a really very, very important topic. Thank you, Rosanna, also. And I know you're very, very busy. Everybody's very busy. We really appreciate your time. I'm not going to keep you any longer, 9 o'clock tomorrow morning, but just to say that the posters are open for voting, and all you have to do is bring your badge to the reception there and enjoy it with conversation and a cocktail. And see you tomorrow morning. Thank you.